Did you know that the type of green card the USCIS gives you, whether it's for 2 years or 10 years, can completely change your immigration journey? Most couples don't realize how important this difference is until it's too late. The good news? Members of our Marriage Immigration Method program are fully prepared for both scenarios, and by the end of this video, you will as well. We're breaking down the difference between the 2-year and 10-year green card, what removal of conditions actually means, and why understanding the full marriage-based immigration process is so crucial. Now let's get started. If you've been married for less than 2 years when your green card is approved, you'll receive a conditional 2-year green card. Otherwise, you'll get a 10-year green card. The key difference? The 2-year green card requires an extra step in your marriage immigration journey. And this extra step is to file Form I-751 to remove conditions on your temporary green card. Now, why does the US government have this requirement? Namely, it's because they presume that every single marriage case they receive is fraudulent. So, young relationships are subject to higher scrutiny to ensure that the marriage is bona fide and not solely for immigration purposes. One big issue that couples face after receiving their temporary green card is failing to remove conditions on time, since this can lead to green card expiration and even deportation risks. The USCIS takes this process very seriously, so it's critical to file Form I-751 properly and provide strong evidence. In order to timely file for the removal of conditions, you must submit Form I-751 during the 90-day window before your green card expires to avoid severe consequences like losing your lawful status or being referred to immigration court. It's important to note that often couples mistakenly file Form I-90 and just sit and wait for an approval. But that's not the right form to file and will waste a lot of your time. Just to clarify, this step is not just a formality. It's a detailed process requiring you to submit updated evidence of your marital life, such as joint bank statements, tax returns, photos, and shared leases. Many people assume it's as simple as sending in a few documents, but it's often as complex as your initial adjustment of status filing, with just less forms, and may even require an interview for approval. Here's the kicker. Most immigration lawyers charge at least $3,000 to handle Form I-751. And if the USCIS issues a request for evidence, also known as an RFE, often due to insufficient or unclear documentation, you're looking at an additional $2,000 or more in lawyer fees to address it. That's not even including the potential delays RFEs create. What's worse, while interviews for I-751 have been waived for many well-prepared applicants, couples who submit incomplete or weak applications are far more likely to be called in for an interview. At that point, the stakes are high, as the USCIS and their officers will scrutinize your relationship. Proper preparation and organization are key to avoiding these costly complications, and it's why understanding and handling this step correctly is so important. We are here to help. With our marriage immigration method, you'll have the first and only complete solution to guide you through all of the 3 steps of your marriage immigration journey. We even cover RFEs without any additional fees, so you can navigate the process with total confidence and no hidden costs. Picture this, filing your forms correctly, avoiding unnecessary interviews, and saving thousands in legal fees, all while staying stress-free. That's the kind of peace of mind our program offers. Be sure to book a free call with us today to learn how we can help you go from unsure to completely prepared at every stage of your journey. The link is in the description and comments below. Now that you understand why the removal of conditions is such an important milestone, let's zoom out and look at the bigger picture, the full marriage immigration journey. It's easy to focus on the adjustment of status, especially when it feels like such a huge hurdle. But here's the truth. Securing your green card is just the beginning. Each stage of the process, adjustment of status, removal of conditions, and eventually naturalization, connects seamlessly to the next, forming a single continuous journey. Think of it like navigating a complex road trip. Adjustment of status might be your first big destination, but the rest of the journey still needs careful planning. If you miss a turn or hit a roadblock during one stage, it can delay or complicate the rest. So let's break down how these 3 steps work together and why understanding the entire process from the start is so crucial. The adjustment of status through Form I-45 is the application for a green card that will allow you to live and work legally in the US. This step requires detailed paperwork, including proving the legitimacy of your marriage through evidence like joint finances and shared living arrangements. Following this process, many couples must then go through the removal of conditions process, which we described above. This process is essentially the adjustment of status 2.0, where you once again must prove the legitimacy of your relationship using brand new evidence. At this stage, the stakes are much higher because the US government is committing to providing you with a permanent green card, which means the likelihood of having an interview is there. especially if your first one got waived and your I-751 petition is incomplete. And then the final step is applying for U.S. citizenship through naturalization. This is the culmination of your immigration journey, providing you with the full rights and benefits of being a U.S. citizen, from voting to greater travel freedom. Now, you're eligible to apply 3 years after receiving your green card if you're still married to a U.S. citizen, or 5 years if not. However, this step doesn't exist in isolation. It builds directly on the foundation you've set in the earlier steps. Errors or delays in your green card or removal of conditions process can definitely impact your timeline for citizenship. Now that we've mapped out the full marriage immigration journey, let's address some of the most common questions couples have along the way. These FAQs will not only clear up any lingering doubts, but also give you actionable steps to navigate the process more smoothly and confidently. First, what if we get divorced before filing to remove conditions? If your marriage ends before you file Form I-751, you can still apply to remove conditions by requesting a waiver. However, you'll need to provide strong evidence that the marriage was genuine, even if it didn't last. Do we need to hire a lawyer for every step of the process? Not necessarily. While lawyers can be helpful for complex cases, many couples successfully handle their applications with proper guidance and resources. Knowing what to include and how to avoid common pitfalls is key. What evidence should we include when filing Form I-751? Updated evidence of your marriage is crucial. This includes joint financial records, photos from the last 2 years, proof of shared residence, and affidavits from friends and family. Think of it as a chance to show how your relationship has evolved. What happens if we miss the deadline to file Form I-751? Missing the deadline can put your status at risk and even lead to removal of proceedings. If this happens, file as soon as possible and include a valid explanation for the delay. Do we need an interview for every step of the process? Not always. Many couples avoid interviews for adjustment of status or removal of conditions by submitting a strong, well-organized application. However, the USCIS can request an interview if they need more information or even make them mandatory for everyone, just as a policy update. Will I be able to work and travel with an expired green card? Yes. The USCIS will send you an extension letter, currently valid for 48 months. During this time, you'll be able to travel with your expired green card and an original letter you receive from the USCIS. How long does each step of the process take? Now, timelines vary depending on your USCIS service center, case complexity, and any RFEs. Adjustment of status can take 8 to 12 months, removal of condition 12 to 24 months, and although we've seen some super fast approvals, this step normally takes a long time to adjudicate. And naturalization, 6 to 10 months after filing, although members of our program are getting approvals 60% faster than national averages. And now for the pro tip, don't lose momentum after getting your green card. Getting your green card is an exciting milestone, and it's easy to relax and put immigration on the back burner. But here's the thing, this is the perfect time to ride the momentum and start preparing for the next step. Removal of conditions. Now is the time to start collecting new evidence right away, such as updated joint bank statements, utility bills, and photos. Pay special attention to big life updates like a new lease, a shared car purchase, or even having a baby, as these events strongly demonstrate the ongoing legitimacy of your marriage. This form cannot be filed online, so you might as well get a folder where you collect all the new evidence over time. By staying proactive, you not only avoid the stress of scrambling to meet the deadline for filing Form I-751, but also position yourself to file as soon as the 90-day window opens. Filing early saves time on the overall processing of your case and brings you one step closer to securing your 10-year green card with minimal delays. Remember, every bit of effort now can pay off later in time saved and stress avoided. So to give you a head start, we think this video would be great for you to check out next. See you there.